So this is lecture 14 of the Business Law and Practice course, and is on the subject of employment law. So let's start by looking at the outcomes for today's lecture. We're going to look at a limited range of areas today, given that employment law is a large topic. So after this lecture, you'll be familiar with the notice requirements for terminating employment contracts, and you'll be familiar with the law relating to both wrongful dismissal and unfair dismissal. And you'll also understand the significance of employment law in the context of directors' service contracts, which of course is something of particular interest in BLP. So, as already mentioned, this is really an introductory lecture looking at some basic topics. We are only looking at the subject at quite an introductory level. If this is a topic which you're interested in, there is of course an elective on the subject of employment that you can choose to study. Part-time students who are listening to this lecture may of course have already studied employment law, in which case this recording will act as revision. So let's start by looking then at the written contract of employment. That's something we're going to look at first, and that's the start of this recording. So the first point is mentioned here on the slide. There is a basic statutory requirement to provide a written statement of terms to all new employees as a minimum. So it's a statutory requirement to provide a written statement of terms, but it's common in practice to go beyond this, of course, and provide a full written contract. We're going to see later on in this lecture what the consequences are if indeed the required basic written statement is not provided. It is, however, to the benefit of both parties if there's a written contract of employment giving details of the terms that apply between the parties. If there is a written contract of employment, the employer will want to provide themselves with as much flexibility as possible, of course, and typically they can be flexible about the duties he can require the employee to perform and also the hours when they can be made to work. It's also possible to put in a mobility clause that will enable the employer to move the employee to other workplaces, and without this flexibility, unilateral changes in the contract could of course be a breach of contract. The employer may also want to prevent the employee working for a competitor or soliciting customers or clients once they have left. So a restrictive covenant may be inserted, although note that this must protect a legitimate interest, for example in relation to trade secrets or customers, and has to be reasonable in area and duration. If it is a lengthy restrictive covenant, it's likely to be considered unreasonable and therefore void. As regards directors, a written contract is likely to be essential. It's impossible to just base things without a written contract because, of course, a director can be an office holder without being an employee. So it's important that there's a written contract setting out the details between them. And commonly, these are, of course, referred to as service contracts or service agreements. We're going to move on now, having talked about contracts, to look at the question of dismissal or bringing the employment to an end. The first issue that we need to consider is that of what notice period has to be given to bring the employment contract to an end. The contract, of course, may be fixed term or indefinite. If the contract is for a fixed term, then there is no right to terminate early, although in some exceptional contracts, an express break clause may be inserted. This means that if it is a fixed term contract, any early termination, even with notice, is a breach of contract. And remember, of course, service contracts for directors commonly are fixed term, as we'll see when we look at these in BLP. Indefinite contracts can only be terminated with notice. However, if no express notice period is stated, the contract will be deemed to contain an implied term that the period of notice will be a reasonable one. This will, of course, vary with the circumstances. Thus, the higher the status of the employee, the greater his qualifications and length of service, the longer the reasonable expectation of notice will be. Those in higher management, for example, would probably reasonably expect a period of notice of at least 6 months. Unskilled staff on the factory shop floor can probably expect no more than the statutory minimum. All that the statute lays down here is the rock bottom minimum period of notice, which will apply if the contractual period is less. The statutory minimum is basically 1 week in the first 2 years, increasing to 2 weeks after 2 complete years, 3 weeks after 3 years, etc. The maximum period of minimum notice under statute is 12 weeks for those employees who have been employed for 12 years or more. As can be seen, the statutory minimum is not very generous. It's not unusual for standard written statements of terms to provide only for this minimum and no more. However, as already mentioned, this is the minimum figure, and the requirements of reasonable notice will mean that the period of notice required for skilled and senior employees is considerably longer than the statutory minimum. In relation to dismissal, there are 4 possible claims to consider. However, note that for the purposes of BLP, we focus only on the first 2, wrongful dismissal and unfair dismissal, which is why redundancy and discrimination appear in square brackets on the slide. So the first of the possible claims is wrongful dismissal. And wrongful dismissal is a contractual claim. It describes a dismissal which is in breach of contract. Hence, an employee whose fixed-term contract is terminated early will be entitled to damages, lost wages for the rest of the fixed term. If it's not fixed term and he is dismissed without notice, then the employee will be entitled to lost pay for the notice period, and indeed will often be paid this in lieu of notice. The second possibility is unfair dismissal. This is more in the nature of a statutory tort, really, a claim that the employer, even though he fulfilled the contract, had no good reason for the dismissal or acted unreasonably in dismissing. It's only available to employees who've been employed for at least 2 years, but the remedies are usually more substantial since the compensation can cover the full period of unemployment and not just the rest of the contract. There is, however, a maximum payment. And remember, of course, for directors' service contracts, if it's a long fixed-term contract, then the payment for the rest of that contract, if it's terminated, could, of course, be quite substantial. So, mentioned on the slide here is redundancy in square brackets. We don't look at this. And finally, discrimination. We don't look at this in detail, but it is an important claim in the sphere of employment law, given that such claims do not have a cap in terms of the amount that can be claimed. It's perfectly possible that claims can overlap, and we'll talk about this more later. There's now a requirement that anyone considering bringing a claim to an employment tribunal must make an early conciliation notification to ACAS to see if the claim can be resolved through conciliation rather than proceeding via a tribunal hearing. As mentioned earlier, we're focusing on wrongful dismissal, that's the contract claim, and unfair dismissal in BLP. Let's try then to talk about wrongful dismissal. So this is the claim that the contract was terminated in breach of its terms. This may be because the employer has ended a fixed-term contract early or an indefinite term without giving contractual notice. A claim for wrongful dismissal can arise in a constructive dismissal situation as well. So a claim for wrongful dismissal can arise in a constructive dismissal situation. That's where the employer has been guilty of a breach of the employment contract. For example, reducing pay and the employee is forced to resign as a result. When an employee has to resign in these circumstances, it's known as constructive dismissal. So wrongful dismissal then, as we said, is a contractual claim, and the employer has breached the contract by not giving the required notice. The wrongful dismissal claim is for the lost wages and benefits for the rest of the contract term or notice. As contract damages put the employee back in the position he would be if the contract were properly performed, the pay should be calculated as net take-home pay, as this is what he would have earned if the contract had been performed. The employee is, of course, under a duty to mitigate their loss by finding suitable alternative employment. Hence, if they refuse a reasonable job opportunity, this will reduce the damages. A claim for wrongful dismissal may go to the county court or the high court, depending on its complexity. It can equally be brought in the employment tribunal if it is for under the threshold of £25,000. But the time limit for bringing the complaint in the employment tribunal is only 3 months. In the ordinary courts, the limitation period for wrongful dismissal would be the same as for any other claim for breach of contract, which is, of course, 6 years. So, just to say a few words about unfair dismissal, and these points are also relevant, in fact, to redundancy. The statutory claim of unfair dismissal and also redundancy depend on the employee having been continuously employed for at least 2 years. So for all employees, 2 years continuous service is necessary to mount a claim for either unfair dismissal or redundancy. This means that if the employee is dismissed after, say, 20 months, he will only be able to mount a claim for the contractual claim of wrongful dismissal, because there will be no right to bring one of the statutory claims. The only exceptions to this rule are exceptional cases such as discrimination, pregnancy, or trade union activities where no period of continuous employment is required. The period of continuous employment is calculated up to what is known as the EDT, or effective date of termination. This is usually the last date the employee worked. However, if an employee is dismissed without notice, the rules in Section 97 of the Employment Rights Act require you add on the minimum period of notice. Thus, an employee dismissed after 1 year, 11 months and 3 weeks would still qualify, as you have to add on the minimum period of a week. This prevents the employer from removing an employee who is on the brink of qualifying. The employee has the burden of showing that they have been dismissed. Dismissed has a broad meaning, including constructive dismissal, which we have already discussed. Thus, as well as termination by the employer, with or without notice, the employee can also rely on constructive dismissal. This is where the employer has been guilty of a repudiatory breach of contract. That is one so serious the employee is entitled to treat themselves as discharged. Clearly, an employee is entitled to resign in response to unilateral changes to his contract to his detriment, such as a cut in pay. However, behaviour which undermines the obligation of mutual trust and confidence would also be repudiatory. Many cases may be decided on this argument, for example, cases of sexual harassment or continuous abuse by the employer. The third type of dismissal, listed on the slide here, is one which would not be recognised as such at common law. Even though the contractual fixed term has expired, the failure to renew the contract will count as a dismissal for the purposes of the statutory claims of both unfair dismissal and redundancy. So let's move on now to talk a bit more about unfair dismissal. If the employee is claiming unfair dismissal, then the employee first has to show they're eligible, that they are an employee, and that they've been dismissed, which may of course be constructive dismissal. Some types are automatically unfair, for example, pregnancy or joining a trade union. However, in the majority of cases, once it's been established that someone is an employee and has been dismissed, it is then up to the employer to show that the reason for the dismissal was what it was, and it fell within certain statutory categories of acceptable or fair reason. If the reason does not fall within these statutory categories, then dismissal is considered unfair. If, however, the reason is considered acceptable, this is just the first stage of the test. The tribunal must still go on to consider whether the employee acted reasonably in treating this reason as sufficient for dismissal. This may well involve considerations of whether a fair procedure was followed. So let's now look at the potentially fair reasons. They're set out in Section 98 of the Act. Capability may include questions of qualifications or competence for the job, as well as issues of sickness or incapacity. Conduct includes disciplinary matters at work, but also bad conduct elsewhere, which may affect the employee's job. For example, theft by someone outside work would be very relevant if they worked in a bank. Redundancy is the statutory definition. Illegality might include cases where, for example, the employee is employed to drive as a driver, but has been disqualified from driving as a result of motoring offences. And then you'll see here a final category of some other substantial reason, which might cover, for example, substantial changes in the employee's contracts, which do not amount to redundancy. So then we need to move on to talk about procedural fairness. Once the reason has been determined by the tribunal, it still, as we say, has to look at whether a reasonable employee would have dismissed for that reason. And that may well depend on the procedures that have been followed. Here, the tribunal must take into account the guidance from the Advisory, Conciliation and Arbitration Service, ACAS, as to what they consider to be reasonable procedures. Thus, in disciplinary matters, the employer should not dismiss for the first offence. The recommended procedures include having firstly an interview, leading to an oral warning. Then on the second offence, it gets more formal. Following a hearing, the employee will be given a final written warning. If you do this again, you will be dismissed. Then, if there is a third offence, the employee can be dismissed, following a proper disciplinary hearing. Unless the business is very small, procedures should be formalised in writing, proper hearing should be held where the employee has the right to be represented by another employee, and proper records should be kept. If it's all done by the book, the employer should find it relatively easy to show that they have satisfied the requirements of a fair procedure. Not every offence, of course, requires a warning. Serious offences can result in instant dismissal even without notice. However, it's still essential proper hearings are held to establish the facts. The ACAS code is not a regulatory straitjacket. It will be followed in all but exceptional cases, and tribunals are authorised to increase awards by up to 25% if the code is not followed. They can also add on 2 to 4 weeks' pay if the employer did not provide the employee with a written statement of employment as required. So moving on to say a bit more about unfair dismissal, the basic award for this is calculated in a similar way to payments for redundancy. The remedies to unfair dismissal can include reinstatement or re-engagement, but it's rare that these are asked for in practice, and in most cases the employee will indicate they don't want these remedies, in which case it's compensation only, and the calculation of compensation involves 2 elements as mentioned here. The basic award, which is, as I said, basically the same calculation as for redundancy, and we'll look at the next slide for detail shortly, and the tribunal will then, however, award a compensatory award, which is what is just and equitable, having regard to the employee's losses. Obviously, a major element in this will be the lost net pay for the future period of unemployment until the tribunal would reasonably expect the employee to find a new job. He has, of course, a duty to mitigate at this time. Other elements would include loss of benefits and loss of future pension rights, and an element to cover the loss of protection against unfair dismissal, at least for the first 2 years in the new job. Since tribunals have to consider what the employee would reasonably expect from a reasonable employer, they have traditionally awarded lost notice money as gross pay. This is because good employers traditionally pay gross pay in lieu of notice. The employee may also be entitled to holiday pay if they have not taken their full entitlement. The maximum amount of the compensatory award is capped at a set figure or 1 year's pay, whichever is the lower figure, and the current maximum figure for unfair dismissal is set out on your copy of this slide. For higher awards or settlements, you need to think about tax. The general rule is that an exemption from tax will cover all termination payments up to a maximum of £30,000, but amounts above this figure will be taxed. Given that the bulk of the award or settlement will be made up of future lost net earnings, it's essential any lost earnings are calculated as a gross amount. If the amount was left at net lost earnings, they would in effect be double taxation. The final point on this slide concerns an exception to the general rule that the first £30,000 of a termination payment is tax-free. The exception does not apply if the employment contract includes an express provision for payment of compensation in lieu of notice. This is what is known as a pile-on clause. If there is a pile-on clause, or alternatively, a payment for discrimination, injury to feelings award, then in those cases, those types of payments are treated as taxable in the hands of the employee. So that's an exception to the usual rule there. So there's a slide here where we're looking at the basic award for unfair dismissal and how it's calculated. So let's just take a look at that for a moment here. You'll see the details of the calculation on the slide here. So let's just take a moment to look at this. So we can see here then the calculation, which, as I said, is the same as for the calculation for redundancy. We can see here the details of how you do that calculation, which are set out here. And we've got in particular the details that the basic calculation takes the final week's pay and multiplies it by the number of years of completed service. However, first of all, a week's pay is subject to a statutory maximum, and the current maximum final week's pay is set out on your copy of this slide in the materials in front of you. Secondly, you can only count a maximum of 20 years service. And thirdly, there is an age factor. You have to add an extra half week's pay for each complete year since the 41st birthday. The maximum statutory basic award pay here you can be entitled to is set out. So you've got the figure set out on your copy of this slide. And so that's just basically how the calculation is done. And so you can see the details there. Now let's move on just to say a few words about discrimination. As mentioned earlier, we're not really looking at this claim in any detail on this course because we only look at employment law briefly and focus in particular, of course, on directors and service contracts. But you need to be aware of this. Note in particular that there is no limit on the compensation, and that's what makes this important. And remember, of course, that you can have claims for a variety of different heads. So you could have a claim for wrongful dismissal, unfair dismissal, and discrimination, also potentially redundancy payment. So you can have a number of different claims that arise. Just to be aware, as you would expect, the statutory rights, especially those in relation to unfair dismissal and redundancy, are mandatory, and you can't remove them, and anything even after dismissal requires involvement of ACAS or the employee's legal advisor. The only exception to this general rule is the new category of employee shareholders, where workers agree to give up some of their employment rights in return for shares in the company they work for. This is a relatively new idea, and it remains to be seen how many people choose to become employee shareholders. It's not expected to apply to many people. So in the vast majority of cases, i.e. in a normal employment situation, the general rule of no contracting out continues to apply. So let's return to our outcomes for this lecture. You should now be familiar with the notice requirements for terminating employment contracts, be familiar with the law relating to wrongful dismissal and unfair dismissal, and also understand the significance of employment law in the context of director service contracts. And that's the end of this lecture.